Hi everyone, my name's Sarah Gordon, also known as H for long and boring reasons that I won't go into now. A lot of people have been asking me about the general data protection regulations that are coming into force in May 2018 and how they could possibly impact on recruiters. So here's my little introduction. The first thing I should say is that although there are some changes, there's nothing earth-shatteringly major if you're already operating good practice. If you're already registered with the Information Commissioner's Office, then the same rules that apply to you now will apply to you in future as well. It will include manual records, so if someone makes a subject access request, you will be required to produce manual records as well as computerised ones. They have introduced a new accountability requirement. This means that you're going to have to be able to show how you comply with the data protection regulations. So you're going to need to be able to produce policies, procedures, and be very clear on how you are complying. Then there's some stuff around lawfulness of processing personal data. Sometimes obviously you'll need to do this for legal compliance reasons, like taking a copy of someone's passport to prove entitlement to work in the UK, sometimes to form a contract with them. The key thing is where they give you consent to process their personal data, they have to actively give that consent. It's not enough now for them just to opt out, or at least it won't be from May 2018. The GDPR also introduces 8 new individuals' rights. The first one is the right to be informed. Now that's generally around your data protection policy. So what information are you storing? How long are you keeping it? What are you using it for? And what rights does the individual have? So really your data protection policy should outline the 8 individuals' rights for people. The second right of access, it already exists, but what they're doing in the GDPR is removing the right to charge £10. You can ask for a reasonable fee, i.e. the cost of producing the information, if their request is excessive, and they've reduced the amount of time you have to respond from 40 days to 1 month. The right to rectification, if there's anything incorrect on their record, again, you are obliged to correct that within 1 month. Right number 4 is the right to erasure, not that kind of erasure, despite the photograph. Essentially, this is the right to be forgotten. So if there is no legal reason that you have to keep the information, if they ask to be removed, then they should be. They have the right to restrict processing, i.e. you can keep the data but not actually do anything with it. And they have the right to data portability. So if you're storing information electronically, you should be able to export it to them electronically too. The 7th right is a right to object. This is mainly regarding direct marketing, so if someone asks to be taken off a mailing list, obviously you have to do that straight away, no questions asked. Then number 8 is rights regarding automated decision making and profiling. Now obviously in an industry like recruitment where AI and clever technology is increasingly being used to make decisions, this could have an impact. This 8th right gives individuals the right to demand human intervention and to refuse to accept any decisions that have been made by an automated decision-making process. So if you are using AI or assistive technology or any kind of clever tech to help in your selection process, it's really important that candidates know this right from the outset. The other exception is if it's authorised by law or necessary to enter into a contract. I mentioned earlier the principle of accountability in terms of showing how you comply. This seems fairly straightforward, and if you have a robust data protection policy, you train your staff, you conduct regular internal audits of your data protection policies and procedures, and you keep up to date with the security features of all your systems and make sure they're adequate, this should be sufficient under the new regulations. In terms of internal record keeping, you need to record the name and details of the organisation and your data controller. You need to be clear on what you're processing, about who, why you're processing it, who you're sharing it with and why, how long you're keeping the data, and how you keep it safe. What are your security measures? Data breaches must be reported to the Information Commissioner's Office if they're perceived to be a risk, and they have to be communicated to the individual if it's a high risk, i.e. it puts them at risk of ID fraud, for example, within 72 hours. So none of this sort of Yahoo coming back to you saying, oh, there was a security breach last December. In future, that won't be good enough. Companies will face a fine if they don't comply with this 72-hour deadline. The GDPR also talk about data protection impact assessments. So basically, whenever you have a new system or you introduce a new piece of technology or a new process, think about how it might impact on data protection and make a note of it. So you've got a record so you can show how you're continuing to be mindful of data protection at all times. So I hope that's answered a few questions for you on the forthcoming GDPR. The key things really to think about are being able to demonstrate your compliance, so having a really good data protection policy in place, keeping a record of any impact assessments that you do on any changes in how you work with data. Also, the new 8 individual rights, making sure that you're communicating those effectively to the people you deal with. Thanks very much for watching. I'm Sarah H. Gordon. My company is Recruit Mentoring. The website address is there on your screen. My mobile number is there too, so if you've got any questions or if you have suggestions for other videos, do get in touch. You can follow me on Twitter too, @SarahHGordon1. I hope you found this helpful. Thanks.